Good, thanks. Okay, good morning everyone. I hope you had a good break in the mid-semester break. So this week we are going to finish pure economic loss in negligence. So what we are going to be looking at is sui generis cases of liability for pure economic loss. And so we're going to be focusing on three situations: inaccurate references, solicitors' wills and disappointed beneficiaries, and defective buildings. And so today we'll cover 1 and 2, and we'll make a start on number 3. Yes, so I think what we need to do first, though, is just kind of remind ourselves of where we got to. Now, remember when we were talking about negligent misstatements and the path to a duty of care in a negligent misstatement is to find an assumption of responsibility. So the principle of assumption of responsibility also applies not just to negligent advice or information, but it also applies to negligent services. So if you can show that a defendant has reasonably given a claimant the impression that the defendant can be relied on to take care in dealing with a certain matter for the claimant, and the claimant relies on the defendant, then a duty of care will arise. Okay, even when this is services, not just information or a statement. Now, often these are very straightforward. So, for example, a solicitor who handles a case or a transaction will owe a duty of care to their client to exercise reasonable care in providing those legal services around that case or that transaction. The same applies to barristers. Now, once upon a time, barristers used to have an immunity that they didn't owe a duty of care to their client. Their duty was really just to the court. But that's no longer the case. The New Zealand Supreme Court got rid of that immunity in the decision Lai and Chamberlain. That's in the reading list. It's entirely optional if you want to read it. So an architect will owe a duty of care to their client who has commissioned them to design them a building. They will owe a duty to take the reasonable care expected of an architect in providing those architectural services. An accountant will owe a duty of care to their client who has commissioned the accountant to draw up a set of accounts, to do so with the care and skill that a reasonably competent accountant would exercise. Okay, so if you can show an assumption of responsibility, then a duty of care will arise in the provision of services. The reason we're talking about these as sui generis cases is because we can't quite show an assumption of responsibility here, but a duty of care is owed anyway. Okay, that's why we're talking about them as sui generis. But before we get on to that, I also just want us to kind of step back and remember that very first discussion we had about the difference between what we have and what we desire to acquire. So we already have our body and our property, and that's why everyone owes us a duty of care not to cause foreseeable damage to our property or our body. And that's broadly the end of an inquiry before a duty of care is owed. But if we want someone to have legal responsibility to take care in giving us something we desire to acquire, so whether it's information or services, if we want them to confer a benefit on us, they generally need to do something extra that gives us this right. And that's where this assumption of responsibility comes in. And the ideal of the assumption of responsibility is that these two parties, they came together before the duty was owed and they had this opportunity to bargain. Okay, and the defendant chose to give the report or do whatever they did. And at that time, the defendant had the opportunity to limit their liability, to disclaim responsibility if they wanted to. They could set the terms on which they were prepared to hand over the information. They had some control over the liability and the risk that was attaching to what they decided to do. So the assumption of responsibility is a very principled exception to the general rule that we don't owe a duty to confer it's a principled reason behind recognition of duties of care to confer benefits. But sometimes coherency or clear principle in the law butts up against a desire to do practical justice. And we're going to look at cases where this happened. And so when I talk about practical justice, what I mean is that, the courts are essentially standing back and they're looking at a situation where the defendant has done something and the claimant has suffered loss, economic loss as a result, and they're asking, who should actually bear this loss here? What's fair, just, and reasonable? So we're going to look at three different scenarios where a duty to take care to avoid causing the claimant to suffer economic loss has been recognised in the absence of something that clearly falls within an assumption of responsibility. And so when I say sui generis, this essentially means belonging to a species all of its own. So it's unique. They say, well, we're going to recognise liability here. Often the courts say this is sui generis. Doesn't mean we're going to then recognise it in another situation that's slightly different. Like it doesn't lend itself to that same kind of general application. It's more in a boundary. They say we're recognising it here for these reasons. It doesn't mean we're going to reason analogously and recognise it in a slightly different situation. There's something very specific about this specific situation, which is why we're limiting the duty of care here. Now, often policy reasons play quite a big factor in the imposition of a duty. And what we will see is that the UK cases are generally much more conservative than other Commonwealth countries. So, outside negligent misstatement, there's a real divergence in the approaches that are taken between the UK and New Zealand regarding pure economic loss. So both countries for negligent misstatements generally require an assumption of responsibility. In the UK, the general rule is that there is no liability for pure economic loss unless there is an assumption of responsibility or something that can be squeezed very closely within those tramlines. There are some exceptions to this, and we'll discuss one of them, but they're very rare. In New Zealand, there is no such general rule. So, negligent misstatement in New Zealand, you need an assumption of responsibility. Just before the break, we talked about relational economic loss. The New Zealand approach isn't entirely clear. There are a couple of High Court cases which rely on ands and look just towards a known plaintiff, but indeterminacy is understood as a real threat. There's some kind of hints that we might go down the Canadian way and have a broad exclusionary rule subject to limited exceptions, the most significant being the joint venture. And now we have these sui generis cases. Now, in contrast to the approach that the UK takes, New Zealand approaches these sui generis cases through the broad ands framework. Okay, they just look at proximity and policy. The fact that the loss is economic is treated merely as a factor that may tell against a duty or limit the scope of liability. But it doesn't frame the inquiry in New Zealand the way it frames the inquiry in the UK. So the UK say it's economic loss, you need to show an assumption of responsibility. New Zealand says it's economic loss, that's interesting, that's a relevant factor, but let's go down the ands approach. Okay, does everyone understand that kind of broad distinction? Yep. Now, the problem with this approach that New Zealand takes is that it can lead to what can look like ad hoc decision making, and it can lead to uncertainty. And so some of you will be thinking, why do we even care about the UK approach? We're in New Zealand, just tell us what the law is in New Zealand so that we know what to do. Problem comes up in New Zealand. The reason we look to the UK as a comparator is because the New Zealand approach has actually been criticised, both, by commentators within New Zealand, by people looking from outside New Zealand in. And the reason it's been criticised is because of its uncertainty. If you're in practice and a client comes to you and asks you for advice on the risks of a certain activity they want to carry out, and the kind of things, the impacts this might have, and if it causes economic loss, etc., it can be very difficult to advise them because the New Zealand approach seems to be consider everything. So consider everything internal to the parties and consider everything external to the parties. And from there, we'll decide what's fair, just and reasonable. And in contrast, the approach that the UK takes, you're kind of on more solid foundations. It seems to be, okay, well, this is the starting point. Then the question is, okay, we've got to here, and how much further are we asking the law to move? Now, you do need sometimes a bit of flexibility. Sometimes the UK approach can be criticised because it's justice might not always be achieved in the UK. But at least, people have this idea that they know what the law expects of them before they undertake the activity. And so we've got this kind of broader spectrum. New Zealand is very flexible, and certainly it was extremely flexible in the time of Justice Cook and Justice Richardson. The UK is more strict in its approach, but there is some more recent New Zealand jurisprudence that indicates that maybe the New Zealand approach is becoming less wide open, and maybe it is moving more incrementally. And in fact, I'll just scroll down here because I've put a quote up. See, Justice Mellon and Strathboss, novel duties of care develop incrementally with reference to their closest analogies in the existing law. This maintains the coherence of the law and avoids inappropriate distinctions. So we've got these more recent statements that indicate maybe New Zealand is going to tighten its belt, in contrast to always taking this wide open ANZ approach. But that's just a bit of an introduction, just so that you know kind of where we're going with this. So what we're going to do is talk about the reference case first. This is quite an odd case. And we'll look at the policy reasons. One thing that's quite interesting about these sui generis cases is that the policy reasons which we have talked about, which make courts reluctant to recognise duties of care around economic loss, they're usually always absent in these cases where a duty is recognised outside the kind of tram lines of an assumption of responsibility. So this is quite an odd case. Spring and Guardian Assurance. So Spring was a sales director and office manager for a life insurance company, and his employer was taken over by the defendant, Guardian Assurance, and he was let go. So he then tried to get a new job, and he approached a different life insurance company called Scottish Amicable for a job selling life insurance policies. Now, Scottish Amicable approached the defendant, Guardian Assurance, directly. Okay, so the new prospective employer approached the old employer for a reference about Mr. Spring. This was required under the regulations. And the reference provided stated that Mr. Spring was a man of little to no integrity and could not be regarded as honest. He didn't get the job, and nor he wasn't successful either when he approached two other life assurance companies. Now, it turned out this reference had been negligently prepared. The question here was, did Guardian Assurance owe Spring a duty to take care when preparing a reference so that they were liable for the economic loss he suffered when he was unable to get another job in the industry? Now, show of hands, what's your instinctive thought here? Do you think he should owe a duty of care? Anyone? Yeah, I'm seeing some nods. Yep, seeing some nods. What about anyone disagree? Who thinks no, there shouldn't be a duty of care here? Okay, yep.
I guess, you don't want the former employer to lie.
Yes.
Say that he was a great guy.
No. Yes, exactly. So it can go both ways, right? You don't want it overly positive. You want it to be due care to be taken in the preparation of this so that it's a fair and true reference. Now, how do we distinguish this from the classic negligent misstatement cases? So, on assumption of responsibility. So, it's probably asking you to cast your mind too far back, but one of the distinctions here is who the statement was made to. So who was this statement made to about him being a man of no integrity? It was made to this prospective employer, okay? And who suffered the loss? not the person who the statement was made to, but the person who it was made about. Okay, so this is different from a normal negligent misstatement case. Someone makes a statement to the claimant who relies on that statement and suffers loss. Here, the statement was not made to the claimant, it was made to a third party. That third party relied on it and the claimant suffered loss. Okay, so this is not in a classic assumption of responsibility case. Another distinction, the claimant here, Mr. Spring, did not ask his employer to provide the reference. He didn't solicit the reference and call them up and say, hey, I've applied for a job, can you please provide a reference to this company on my behalf? He didn't even know this was happening. He just applied for the job and the prospective employer called his old employer to ask for the reference without his knowledge. This was all part of the regulations that governed the life insurance industry in the UK. So it's very difficult to show a classic assumption of responsibility here. But the House of Lords still held that a duty of care was owed. Okay, they had the same instinct that you all had when I asked the question. Now, Lord Gough is a real formalist, and his view was that, well, look, if we cannot get these facts within an assumption of responsibility, then there will be no basis on which to find a duty of care in a pure economic loss case. Okay, this is the UK approach. You want liability for pure economic loss, you try and get within those tramlines of an assumption of responsibility. So he really stretched the assumption of responsibility to breaking point. And he relied on Lord Morris's dicta in Headley Burn. See if I can bring that up. Okay, so see this bit here, my lords. I consider that it should now be regarded as settled that if someone possessed of a special skill undertakes, quite irrespective of contract, to apply that skill for the assistance of another person who relies on it, a duty of care will arise. The fact the service is to be given by means of or the instrumentality of words can make no difference. Furthermore, if in a sphere in which the person is so placed that others could reasonably rely upon his judgment or his skill, a person takes it upon himself to give that information or allows it to be passed on to another person, a duty of care will arise. Okay, so he relies on this part of Headley Burn, and he says, well, look, the employer is possessed of special knowledge, derived from his experience of the employee's character, the employee's skill, the employee's diligence in the performance of his duties while working for him. And he said, and he went on over here, okay, this bit here, the employer is possessed of, yep, so you can see that bit. And he goes on to say, well, the reference is provided for the assistance of both the prospective employer and the employee, regardless of who asks for it. So he wasn't particularly bothered about the fact it wasn't solicited by the employee. And it is made either with the express or tacit authority of the employee. And the employee relies on the defendant to exercise due care and skill. Okay, so Lord Gough's way to this was to squeeze it within the tramlines of the Headley Burn assumption of responsibility, notwithstanding that it wasn't made to the claimant but about him, notwithstanding that it wasn't the claimant who directly relied on it, but it was the prospective employer, notwithstanding that the claimant didn't solicit it. The rest of the House of Lords were not so constrained by the Headley Burn assumption of responsibility and the claim for pure economic loss. They said, well, the loss was foreseeable and the relationship was clearly proximate, so the question became, is it fair, just and reasonable to impose a duty? Hedley-Byrne didn't decide the case, but they thought it was unacceptable that the person to whom a reference was given about an employee should be able to sue for negligence under Hedley-Byrne if they relied on the statement and employed X who was inadequate for the job, which was exactly the point that you made earlier. Okay, so if a negligent statement is made to someone who then employs someone who isn't good enough for the job, then they could easily claim under Hedley-Byrne and Heller. That would fall neatly within the assumption of responsibility. And I thought it was very unfair that that person could claim, but the employee about whom a statement had been made could not. So for that reason, they felt that, would have no recourse. They felt that it was very unfair that a claimant about whom the statement was made and is refused employment because a recipient relies on a negligently prepared reference would have no recourse unless they could prove it was given maliciously and defamation, which we'll talk about shortly. Okay, so we've got Lord Gough, who squeezed it and stretched the assumption of responsibility almost to breaking point to find a duty of care here. We've got the other law lords who looked at the assumption of responsibility and how that would apply to the person who received the information and relied on it, and then kind of from that basis made a judgment about what was fair, just and reasonable about the person about whom the reference had been made, and on that basis found a duty. So this is a very, very rare example of a duty being found in the UK that doesn't, aside from Lord Gough, fit within the tramlines of an assumption of responsibility. But it's also important, let's just go back to note, so the policy reasons that usually make courts really reluctant to find a duty of care in relation to economic loss, they were not present here. Okay, so there was no risk of an indeterminate volume of claims or an indeterminate amount of loss. He could only hold down one job at a time. Okay, so Mr. Spring was the only person who was going to suffer loss as a result of this negligently prepared reference. There was no alternative way that Mr. Spring could protect himself here. He was entirely in the hands of his old employer to exercise due care in the provision of the reference. And there was no getting in the way of any contract that would allow recovery. Indeed, there's a suggestion in the case that maybe it's actually, maybe the better path was to claim as an implied term in the employment contract that an employer would exercise due care and skill in the provision of any reference, and then you claim it as breach of contract. Anyway, let's just put that to one side. And in terms of this desire to do practical justice, there's a theory that's been put forward that if a defendant takes on a task, knowing that if they perform it badly, it will positively cause the claimant some harm that could ruin the claimant's life, then the defendant will owe that claimant a duty to perform it with reasonable care and skill, okay, even without an assumption of responsibility. This is the severe dependency explanation. And Lord Lowry, in this decision, said that the duty was based on the probability, often amounting to a certainty, of damage to the individual resulting from a bad reference, which in some cases will be serious and may indeed be irreparable. The entire future prosperity and happiness of someone who is the subject of a damaging reference, which is given carelessly but in perfectly good faith, may be irretrievably blighted. And I think it was the nature of this particular industry that he couldn't really recover from this bad reference. He was trained to work in one industry. This reference got around the whole industry. He couldn't recover from it. His future was irretrievably blighted. Now, the obvious thing you'll be thinking is that this seems to be all about his reputation. What about a defamation claim? Why not just claim under defamation and be done with? Why does it have to be a claim in negligence? The reason for this is that the defence of qualified privilege applies to references unless the reference is given maliciously. So this encourages frank and honest references, which is what we want. We want people to be honest and give a truthful reference about employees. That benefits everybody. And so that was why the claim had to be through negligence, because he couldn't show it had been given maliciously, it had only been given carelessly. It's a tricky case, Spring, but that's the only reference case we're going to talk about. Does anyone have any questions about it before we move on? Okay. So the next set of cases we're going to talk about is the will cases with the disappointed beneficiaries. And we're going to see a real difference in approach here between, surprise, surprise, the New Zealand courts and the UK. So we're starting with the New Zealand decision, Gartside and Sheffield. This decision is from 1983. So there was an 89-year-old testatrix in 1983, and she approached her solicitors and gave them instructions to draw up a will which would have left the residue of her estate to the plaintiff, Gartside. And 7 days later, she died, and this was before any new will had been prepared. Now, this was a strikeout application. So with a strikeout, the court assumes that the facts pleaded are correct, and yet there is no reasonable cause of action shown. So in the lower courts, this had been struck out on the basis that the solicitor who had received instructions from the testator did not owe any duty of care to the intended beneficiary. They had struck it out. They said, no duty of care is owed. It made its way to the Court of Appeal. Now, the Court of Appeal held that a duty of care was owed by the solicitor to the disappointed beneficiary. And look, a lot of these early cases, they do involve President Cook and Justice Richardson, and they were really hot on the freedom of the Anne's approach. So we can see in their legal reasoning that they didn't concern themselves with Hedley Burn. They didn't restrict or change their approach because the loss, if that's what we call it, suffered was economic. They said the mere fact that the only damages either likely to be suffered or in fact suffered are purely economic doesn't necessarily rule out a duty of care. It's just a factor which may in some cases tell against a duty or limit the scope. So we've got this huge divergence in approach between the UK and New Zealand. This is a very soft approach, okay? It's not a negligent misstatement. This is a negligent service. She asked for a new will. She hadn't prepared it. They didn't prepare it before she died. So the New Zealand courts reverted to the Anne's approach. Proximity inquiry first. And the court said, look, the first step is to ask whether, as between the alleged wrongdoer and the person who has suffered damage, there is a sufficient relationship of proximity or neighbourhood such that in the reasonable contemplation of the former, carelessness on his part may be likely to cause damage to the latter, in which case a prima facie duty exists. They thought it was very obvious here that a careless failure on the part of the solicitors would, on their part, to have the will drawn and presented in a timely manner would deprive the intended beneficiary of a benefit. Now, this is particularly so when the age or health of the testatrix demanded urgency. They did not turn their mind at all to the principle of assumption of responsibility. So, prima facie duty of care is clear. Let's have a look at policy. So we've got this affirmative answer to the above. Are there any considerations which ought to maybe negative the duty of care? And the court said, well, actually, there's no risk here. We're going back to these same policy factors that we have seen come up time and time again in these economic loss cases, that, you know, that the absence of them, when they're present, they make it very difficult to find a duty of care, and when they're absent, the courts are more willing to find a duty of care. So the first thing, there was no indeterminacy here, they felt. You know, there was no risk that solicitors would be exposed to liability of an indeterminate amount for an indeterminate time to an indeterminate class. The duty would only be owed to those persons identified in the testamentary instructions provided to the solicitors. The beneficiaries, the proposed beneficiaries under this proposed will, could not protect their own interests. Okay, that reasonable alternative means of protection, not present here. They were entirely in the hands of the solicitor doing their job. They thought that the duty here would march in line with policy. So the public rely on solicitors to prepare effective wills, and it would be a failure of the legal system not to insist on some kind of practical responsibility on the part of the solicitor if they fail to do the job in a timely manner. It was also felt that recognition of a duty would compensate deserving plaintiffs. We can ask some questions around that. But it would also promote professional competence. And in addition, solicitors can protect themselves, so that beneficiaries couldn't protect themselves. They had no way of arranging alternative means of protection here, but the solicitors can protect themselves, and they do so through professional negligence insurance. Now, they did recognise that a feature of this whole testator, solicitor, intended beneficiary category is that, you know, normally what happens is that damages are given to compensate the plaintiff for an impairment of their existing position. You know, normally someone's lost something that they had. Here, the intended beneficiary didn't have anything. They just wanted to get this gain. This was a win. This was a gain. Someone was going to give them some money, and it turned out that the instructions hadn't been completed in time, so they didn't get this gain. Now, it's not usual for tort to step in this kind of situation. Damages representing a benefit that would accrue to a claimant is normally the province of contract law, not tort law. So this is a very odd place for tort law to be operating, and the court did recognise this, but they felt that they could recognise a sui generis duty here confined to the narrow facts of a disappointed intended beneficiary. So that's the New Zealand approach to this problem. Just hit it through ands. Go with proximity, policy, see where you get to. We'll have a break now for 5 minutes. We'll come back at 9:47 And we'll move on to the UK approach, which takes quite a different approach to get to the same result.
Question about the reference cases.
Yes.
How is this case, Spring Guardian, reconcilable with the South Pacific case? Because isn't that kind of similar where I think we learnt it with
Joe, I have to remind myself what South Pacific's all about.
It was the insurance company, and they had a private investigator.
Yeah.
And the investigator negligently told the insurance company that it might be arson, so the people whose property got burnt down couldn't get the insurance payment.
Yeah.
So it was kind of similar where they were making a statement to someone else.
Yes.
And then they couldn't pay out.
Right,
based on
I
that
see.
negligence.
Oh, that's interesting. And so I imagine the way the New Zealand courts approached it was that they said proximity policy.
Yeah.
Yeah. And so they found a duty that way. They said it was reasonably foreseeable if
said
you didn't
no
take
duty.
it. Oh, they said no duty in
They
South
said
Pacific.
no duty because they said it had cut across the well-established principles of defamation.
Ah,
Because they said
interesting.
defamation establishes a balance where you're only liable if it's malicious or you have improper purpose by the
Yeah.
qualified privilege threshold.
Yeah.
Whereas if you impose a negligence, it kind of just overthrows that other area of law.
Right, interesting.
But that wasn't really touched on.
In spring?
Not much.
No, not much. Yeah, so in the spring they said, oh yeah, exactly, it's only malicious, but they felt that. Yeah, what, actually, I did have something which is, what about spring? Doesn't undermine defamation. Yeah, so essentially what they say is defamation is all about reputation, okay? But if we look at spring, not about reputation, but about damage to future prospects. I know, it's a dancing on the head of a pin. It's absolutely dancing on the head of a pin to get a result that they want to get.
And what would happen if, like, you know, those negligent misstatement cases where you have an auditor and you have some company,
Yeah,
if the auditor advises an investor
Yeah.
negligently and the investor decides to not invest in a company,
yeah.
could the company sue because they
Oh,
lost
yeah.
the investment? Would it just be
No.
like,
Because, no, they couldn't sue because they don't have a right to anyone's investment. And the advisor hasn't given them any right at all. So maybe they could sue for maybe they could go for a defamation claim, but they couldn't sue in negligence.
but if you got something like that, you'd still just look at it under the New Zealand Arms approach, and that would be like a policy factor. There would be no proximity because there's no
Exactly. There's no assumption of responsibility. So through a negligence claim, there is no assumption of responsibility for a negligence statement. And New Zealand is pretty consistent about requiring an assumption of responsibility for negligent misstatements. For negligent misstatements, it requires an assumption of responsibility. Outside negligent misstatements for pure economic loss, it takes a more open approach. Yeah. Yeah. Just going back to that, I should remind myself about the South Pacific case, but presumably, once it became clear that it wasn't arson, the insurers were obliged to pay out anyway under the insurance policy.
I'm not sure if that was really the case.
No, maybe it wasn't, but I imagine they got that anyway because that insurance policy would govern the claim, and that would stand, yeah, if it turned out it wasn't arson, then they'd have to pay out. So it would just be limited to a reputation claim. Yeah. Interesting. Yeah, thank you. Okay. So that is the Gartside approach that is the New Zealand approach to the disappointed beneficiary. Okay, proximity, policy, don't worry about assumption of responsibility, just look at what's essentially what's fair, just and reasonable. UK approach, same facts. So we've got White and Jones. This is a 1995 decision. So B quarrelled with his daughters, and as a result of this quarrel, he changed his will, in which he left them nothing. 3 months later, they were reconciled, and he resolved to make a new will, under which his 2 daughters would each get £9,000. So he instructed his solicitors to draw up a new will in these terms, where each daughter, instead of getting nothing, would get £9,000. 2 months later, the solicitors still had not drawn up this new will, and B died. So as a result, the daughters received nothing from their father's estate. So what happens is that the will's just distributed, whatever the previous standing will is, that's how the estate gets distributed. Okay, it's not like they hold on to it while they resolve this problem, they just distribute it, and the claim goes against the solicitor. So they sued the solicitors in negligence, claiming that those solicitors owed them as potential beneficiaries a duty to draw up the new will with a degree of care and skill and do it in a timely manner before their father died. So what I'm going to do with this case is go through the 3 judgments. We're going to spend quite a bit of time on White and Jones because I think it's a really good decision. And you can see how the judges grapple with the problem in an entirely different way to how the New Zealand Court of Appeal did in Gartside. Okay, and you can think about which would you feel, take a view. I want to talk at the end about which view do you feel is the most coherent approach. So Lord Gough was our man who loves the assumption of responsibility, and he cannot see that you can get any liability for economic loss unless you can get within the tram lines of an assumption of responsibility, and if you need to stretch those, then do so. So he says, look, we've got an immediate difficulty here. He identifies 3 key conceptual difficulties with this claim. First conceptual difficulty. A solicitor who is acting on behalf of their client, so in this case the client is the testator, the person who wants to distribute his estate, not the people who might benefit from it, that solicitor owes a duty of care only to their client. They don't owe a duty of care to third parties. Usually it's a contractual relationship and there is a retainer, and the solicitor can stipulate the scope and the terms of his duties in that retainer. In theory, they can put terms to protect themselves in that retainer, limit their liability. But you can never protect yourself against a third party who you don't have a contract with. Okay, so this is the first thing. Solicitor and a client, the solicitor owes the duty to their client, not to third parties. Second conceptual difficulty. This is a claim for pure economic loss. The general rule is that apart from cases involving an assumption of responsibility under Headley-Byrne, no action will lie in respect of such loss in the tort of negligence. And he also said, and it's also not really a loss at all, but a failure to obtain a benefit. But this is a key difference, right? This is already a key difference between the approach taken in New Zealand, where they were not bothered about the fact that it was economic. They weren't bothered about the fact that a solicitor owes a duty to their client, that there needs to be an assumption of responsibility. The third problem is they said, well, if liability is recognised, they wondered, could you put sensible bounds around it? Could you logically restrict it to a specific named potential beneficiary who is disappointed? What about wider indeterminate classes of persons who might have been adversely affected? So he recognised that these conceptual difficulties meant that existing legal concepts could not coherently accommodate this claim. It's a claim for pure economic loss, and there is no assumption of responsibility from the solicitor to the intended beneficiary. The only way in the UK to get a claim for pure economic loss is to fall within the assumption of responsibility. So he recognises these difficulties, and then he turned his mind to this impulse to do practical justice, okay? When you hear the facts of the claim, you think, hold on, do I think there should be a claim here or not? This is this impulse you have to do practical justice. And he said, well, look, there is a lacuna in the law here that needs to be filled. The only person who might have a claim, the testator and his estate, haven't suffered a loss. The only person who has suffered a loss, the disappointed beneficiary, has no claim. So there's this lacuna in the law at the moment that the solicitor gets to benefit from. And he then says, look, legacies have huge importance in society. Citizens have the right to leave their assets to whoever they please. And often this is the only opportunity for those beneficiaries to obtain a significant capital sum which can set them up for life. You know, they might inherit a house. Making sure that desired legacies happen is critically important in society. He then says, well, it wouldn't be unjust to make the solicitor subject to liability because he has wronged someone. He wronged the estate and the testator. Okay, when he didn't put the instructions into a will in time so that the testator's desires were not able to be met. He's just lucky. The solicitor at this point is just lucky that the testator is not the one who suffered the loss. And like the New Zealand decision in Gartside, he said, look, the public rely on solicitors to prepare effective wills. So he is torn between legal coherence, which requires there to be an assumption of responsibility, and practical justice. Okay, legal coherence would suggest no duty here. Practical justice demands a duty. And so he turns his mind to the different paths that might fill this lacuna. Okay, and he rejects each of them, and then he gets back to the law of tort, the janitor of the law. And he says, look, Headley-Byrne cannot help the intended beneficiary. There has been no assumption of responsibility by the solicitor to the intended beneficiary in the terms required by Headley-Byrne. But, he says, we can fill this lacuna by extending to the intended beneficiary a remedy under the Headley-Byrne principle by holding that the assumption of responsibility by the solicitor to the testator could be held in law to extend to the intended beneficiary. Okay, so essentially the intended beneficiary gets to step into the testator's shoes. This is not an assumption of responsibility to the intended beneficiary. They get to step into the testator's shoes in this situation only. It is held in law to extend. What this means is that it's probably more theoretical than real, but any restrictions in the scope of liability and the retainer between the testator, which may exclude or restrict his liability, would also apply to that beneficiary. They step into the testator's shoes and gets the rights that the testator would have, but they bring with them the loss that they have suffered. the liability is not to an indeterminate class, but only to the intended beneficiary. And so essentially his approach is that, Lord Goff is fixated on the assumption of responsibility. In his eyes, that is the only way to make a claim for pure economic loss in the UK. And so he had to tie this. He had to somehow get within the tramlines. And he did this by recognising what assumption of responsibility there had been. That was to the testator, and allowing the intended beneficiary to basically step into the testator's shoes. So that was the approach taken by Lord Goff. Practical justice would then allow the beneficiary to take the benefit of the assumption of responsibility to the testator. Okay, so that's Lord Goff's approach. Lord Brown Wilkinson, he approached it differently. And he approached it through the ideal of incremental development of the common law. So neither of them are just going proximity policy, let's just go with that and see where we get to. One has started from the assumption of responsibility in Headley Burn and looked at how far can we stretch this. Lord Brown Wilkinson, he's looking at incremental development of the common law. So what he did is he looked at occasions where the law in England does impose a duty to avoid causing pure economic loss. Now, he noted that there's no general duty of care to avoid causing economic damage, but there are some certain relationships where that duty does exist. One of these is a Headley Burn assumption of responsibility relationship. So he looked at what are the features of that kind of relationship, okay? And he said, right, well, the defendant agrees to do something and they can foresee that the plaintiff will rely on them. There is actual reliance by the plaintiff, and the defendant accepts responsibility without disclaiming liability. So he looks at the features of a Headley Burn relationship. Now, another kind of relationship where there is a duty not to cause economic loss is a fiduciary relationship. Now, this is a concept you'll come across in equity. But in contrast to an assumption of responsibility, in a fiduciary relationship, there isn't this kind of mutual dealing between the parties. Often the beneficiary might not even be alive, okay? The beneficiary might be someone yet to be born, and there's like a trustee who has to act in the interests of all the beneficiaries of the trust, both alive and yet to be born, etc. Now, equity imposes obligations on fiduciaries because the fiduciary has assumed to act in the beneficiary's affairs. There's no reliance here. There can't be if the beneficiaries aren't yet alive. But the critical thing in a fiduciary relationship is not that the fiduciary knows the beneficiary is relying on them, but they know that the beneficiary's economic well-being is dependent on the fiduciary's careful conduct of the beneficiary's affairs. This is interesting just because you can see how he does this incremental reasoning. So he looks at the features of a relationship of an assumption of responsibility in which a duty of care to avoid causing economic loss can arise. He looks at the features of a fiduciary relationship in which the law imposes duties not to cause economic loss. He looks at the different features of each of these things, and then he looks at the commonalities between the features of those two relationships and the situation that arose here in White and Jones, where we have a solicitor accepting instructions from a testator to benefit third parties. And then he says, look, novel categories of negligence develop incrementally and by analogy with established categories. And he then made the case for liability, concluding that, by accepting these instructions from the testator to draw a will, the solicitor does come into a special relationship with those intended to benefit under it. by drawing out, you can read his judgment to see how he drew out the similarities of the relationships where a duty will be held to exist and how those features were present here. So it's a very clear understanding of the law developing incrementally. It either fits within an existing principle, like an assumption of responsibility or a fiduciary relationship, or it might not. And if it doesn't, then you need to see, well, is there a case to extend it to this novel situation? How far has the law gone? What are the features of those relationships where the law has gone, and how far are we asking it to extend now? And because the step being taken here, it wasn't actually very big when you looked at the commonalities between this relationship and those other situations. It wasn't a very big step. It wasn't a particularly, it didn't make it hugely novel. It was a small step, and it could be justified because it was fair, just, and reasonable to take the step. What do people think about this approach? Like, if you were to look at the approach taken in New Zealand, the approach taken by Lord Gough, and the approach taken by Brown Wilkinson, if you were to think, you know, which has more certainty in terms of being able to advise clients which way the law might go? Which do you feel more, you know, which is clearer, which is on stronger foundations? I don't know if you want to spend 2 minutes just thinking about it, chatting about it, and then we'll bring it back and see what views you have.
I had a question about the difference between New Zealand approach and UK approach. So basically, New Zealand approach, the duty was owed directly to the beneficiary.
Yeah.
But in the UK approach, it's owed to the tester. But
Well, and then they just go in the.
But you can step in the shoes.
Yeah, essentially that's what's happening. They say it extends in law to the beneficiary. They recognise the assumption of responsibility was only to the testator, but held it extended in law. They did a two-step thing.
Oh, okay. But in the UK, so basically the beneficiary is bound to whatever the tester agrees with the.
Yeah.
But the New Zealand approach is it's not
No.
that.
Yeah.
Okay, that's the main difference.
That's one of the differences, yeah.
So what is the main difference?
Well, I mean, it's just the approach that was taken. So one was a proximity, and then, you know, if they had tried to restrict, yeah, I mean, I guess that is, I mean, I don't know if you have named it or not, but one was this proximity approach. They just said, well, it was foreseeable, and it's proximate, therefore there's liability. And it says, well, hold on, we don't just take that approach for pure economics. It's more difficult. So you either need to get within the tramlines of an assumption of responsibility, or we need to kind of reason from existing cases. We don't just shoot from the hip and say, it looks proximate to me, let's just go with it. You know, like it's this really open-ended, loose approach. There's no certain what court will do, versus a very strict, step-by-step approach.
So UK is more step-by-step, and New Zealand is like
Particularly in the time of Cook, very much so. Yeah, that's right. Okay. What do you think? Does anyone have a view? What do you think about Gough compared to Brown Wilkinson compared to the New Zealand approach? If you were a solicitor doing, well, I mean, I guess the law's clear. Yes, Sasha.
I feel like the UK approach worked a lot of is better than New Zealand because there's so much independent liability.
Yeah.
Just look at proximity and policy.
Yeah. It's like, what do you consider? Is that, you know, like you're sitting there going, okay, proximity, let's just look at the general relationship between the parties and it's in reasonable contemplation. So like it's more open-ended. There's less certainty about when there will be liability or not, depending on, it seems to fall back on policy to do most of the work. Does anyone else have a view? What about the difference between Goff and Brown-Wilkinson? Does anyone have any questions? Yes.
I kind of like the Brown-Wilkinson approach
Yep.
for this situation because it links back to what a lawyer is there to do. It's there to have, to act on behalf of their clients, and so looking at what is the existing law around that and extending it. I
Yep.
think the Goff approach to me seems a little forced.
Yep.
I think it actually, that how the law bit, I think it works better for the reference cases.
Yes.
When you've got the regulations we're setting out, you're acting, you have to provide a reference for somebody else. Therefore, you can see that as a real clear assumption of responsibility.
Yes.
Applying that assumption
Yep.
of responsibility
Yep.
rather than opting into it. Whereas this time, sort of stepping into the shoes of another person, there's all the legal methods to do that, and stuff in terms of litigation agreements and all that kind of stuff. Whereas this feels like it's a little bit of a, trying to put a square peg in a round hole.
Right. Yeah, no, it's really insightful. Thanks, Lachlan. Yeah, the forcing it into the tramlines of assumption of responsibility versus looking at how far assumption of responsibility takes you, how far fiduciary relations take you, and reasoning incrementally from there, which is very much the UK approach. No, you're right, forcing a square peg. It is a fiction, is what they were doing. Any other views on it? Is anyone what about the New Zealand approach? Do we have any supporters for the New Zealand approach in here? Am I too biased in the way I teach? There's a certain flexibility, right? Look at what's just and go from there. Okay, so we can leave it there if no one's got anything additional they want to add. So, Lord Mustle, so we've got, we've got Goff, assumption of responsibility, we've got Brown-Wilkinson, incremental reasoning, and then we've got Lord Mustle, and he said no duty, okay? He was the dissenter in this. He felt that no duty should be owed to the intended beneficiaries. He thought it went far beyond the law of negligence. You need mutuality for a special relationship for this Headley-Byrne duty. Mutuality requires reciprocal dealings between the parties. There was no relationship at all between the disappointed beneficiaries and the solicitors. And it's interesting because, I sometimes do think negligence is treated as the kind of janitor to clean up things that are left open by other areas of the law. And he says the real problem here is the rule of succession, that a disposition of property designed to take effect after death is ineffectual unless embodied in a valid will. Maybe there needs to be some more flexibility around that to the extent that, clear intentions of change, clear instructions received by a solicitor to change a will, maybe courts should be more willing to look at those even if the will hasn't yet taken place. Like, what if the instructions are given and then the person dies the day after? So there's no negligence there. It's an interesting question. Does anyone think he was right, that there shouldn't be a duty of care? Or is your feeling that these intended beneficiaries have been wronged and we're entitled to some kind of remedy? No view? Still thinking about it? What we can take from it is that it hasn't expanded beyond this. Okay, the will cases are treated as a sui generis pocket of liability. The difference between the New Zealand and the UK approach is that the UK recognised, identified, understood the conceptual difficulties that the claim presented. You know, they treat claims for pure economic loss differently to other claims, and they are specific about it. They made a real effort to tie the liability to an assumption of responsibility, or at least to reason from the features of an assumption of responsibility, which is what Lord Brown-Wilkinson did. There is clear appreciation that the judges, they can't just recognise liability for pure economic loss because it's fair to do so. They tried to tie it to existing case law. How far has the law gone? What are we asking it to do here? The New Zealand approach was completely different, okay? It was much looser. They didn't constrain themselves at all because the loss was economic. That was just a factor. It didn't change the approach to duty. And just to be very clear, in New Zealand, if you're dealing with a negligent misstatement case, the New Zealand courts will change their approach to duty. Okay, they will go down the assumption of responsibility route if it's a negligent misstatement. But if it's a negligent service like this, they don't constrain themselves. They just go down the proximity policy approach. That is a different approach to the approach taken in the UK, where they will be very cognizant of the type of loss they're dealing with, and they will change the approach to the duty of care, either by requiring, assumption of responsibility, which is a huge part of the UK law in relation to pure economic loss. And if they do reason, if it is a novel case and it doesn't get within assumption of responsibility, you can see the approach taken by Lord Brown-Wilkinson, this kind of incremental. Let's see how far the law has gone. Let's look at the features of those relationships. Let's see how far we're asking the law to go now. Right, so now we're going to just jump over to another case, which isn't a will case, but it is a solicitor-client third-party case. So, Brownie, Wills and Shrimpton. Can Gartside be used to argue that a solicitor owes a duty of care to a non-client in relation to the terms of a guarantee they are signing? So, facts of this case. The facts of these cases, they can sometimes be quite complicated. And, anyway, we'll go through it. So, a firm of solicitors acted for a company. That company had a debt to a bank of $85,000. Now, the solicitors were instructed to act for the bank as well as the company to get the directors of the company to get their signatures for a personal guarantee from each of the directors for the company's debt. There seems to be some major conflict issues here, but let's just put that to one side. But essentially, so the company has a debt of $85,000, and the bank says, yeah, we know about companies. We actually want a personal guarantee from each of your directors for this debt. But, so they ask the bank to make sure they can get these signatures for a personal guarantee from each director for that debt, and they ask the solicitors to explain to each director, before getting the signature, the terms and nature of the guarantee. Critically, this guarantee was unlimited and joint and several. So it meant that each director could be liable for the full 85, but obviously only up to 85. But if 3 directors couldn't pay it and 1 could, well, they were up for the whole lot. Now, one of the directors was Mr. Shrimpton. He went into the solicitor's office and he signed the guarantee. The solicitors did not provide any advice in relation to it. Remember that the bank has asked the solicitors to make sure they know what they're signing? Well, the solicitors didn't do that. He didn't ask for advice, he just signed it. And when he signed it, he assumed his liability was limited to around $15,000. Now, the company then went into liquidation. and demand was made from each of these 5 guarantors. There were 5 directors. Now, Mr. Shrimpton, at this point, was very surprised to find his liability was unlimited, that he had signed a guarantee, joint and several, unlimited liability. So he claimed from the solicitors for the economic loss he suffered when his personal guarantee was called upon and wasn't limited to the 15 he thought he should be liable for. So the question was, did the solicitors owe Mr. Shrimpton, who wasn't a client, a duty to advise him in relation to the terms of the guarantee? And what do you think? Oh, I mean, I probably put the... does anyone have an instinct about what you think is the right answer, regardless of what the court has said here? Yep, Lachlan?
I may be a little bit harsh, but I mean, this is a director of a company who has to deal with legal material all the time.
Yep,
Is invested in the company's interests.
yep,
This is someone who probably should know what they're doing.
yes,
Should read the document
yeah,
without just signing it
Mhm.
and reading
Mhm.
what's going on.
mhm,
And so if you're taking down the essentially the answer to about fair, just and reasonable,
yep,
it's not really. In the interest of fairness, I don't think it's really fair for him to, not read the document,
mhm,
just assume that as a director,
Yeah.
you wouldn't have to pay the
Mhm.
amount.
So there's a lack of vulnerability. He's a sophisticated party. Is that kind of, yeah, that's where you go. Yeah,
And it's like, oops, I didn't actually read the document.
yeah,
So that's a little bit of like, we should be incentivizing, especially companies,
yeah. Reasonable alternative means of protection.
exactly
Yeah.
reading it,
Yeah,
asking what's
yeah,
going on.
exactly.
Before you sign up.
Yeah. I mean, I don't have any sympathy for him either. I think that's right. So, no, there was no liability here. The solicitors did not owe him a duty to advise him in relation to the terms of the guarantee. Now, what were the reasons for this? They did turn their minds to go outside partway through here. You'll see the relevance of bringing it in here shortly. When the bank asked the solicitor to explain, so the bank did ask the solicitors. They said, you need to explain the terms of the guarantee to the directors, okay? The bank were trying to do good by the directors. We want them to sign this guarantee, make sure they know what they're signing. But the solicitor never assumed responsibility to those directors. If it assumed responsibility to anyone, it was to the bank. That was who their relationship was with. It wasn't to the solicitors. Nor had the solicitor done anything which could reasonably have led Mr. Shrimpton to think that the solicitor was undertaking a responsibility to advise him. So it was held that a non-client of a solicitor, unaware that the solicitor's client had requested that the non-client be advised, could not expect advice if they don't give an indication of that expectation to the solicitors. There was no special relationship here. The solicitors did not undertake a responsibility to Mr. Shrimpton to advise him. The solicitors did not do anything that could have led Mr. Shrimpton to think solicitors were undertaking that responsibility. And so essentially they said, well, we know that we didn't bother about assumption of responsibility in the wills cases, but here we are going to bother about it. So it's a very inconsistent and hard to predict approach that's taken in New Zealand. So, Justice Blanchard, a plaintiff who sues in tort alleging economic loss arising from negligent advice given to the plaintiff, including a failure to give advice, needs to prove actual reliance upon the advice or the absence that led the plaintiff to believe it was safe to proceed. The plaintiff must also show that it was reasonably foreseeable in the circumstances that the plaintiff would rely on the defendant as advisor in this way, and to the extent that he did, and that it was reasonable for the plaintiff to do so. Whether that was so in turn depends upon whether the reliance was induced by the conduct of the defendant in assuming or appearing to assume responsibility for advising the plaintiff. So assumption of responsibility is required here before the solicitors will owe any duty of care to a non-client. while the courts recognised they had assumed responsibility to the bank, it didn't follow that they assumed responsibility to Mr. Shrimpton in circumstances where they weren't acting for him. Mr. Shrimpton was completely unaware that the bank had asked the solicitors to advise him, and he didn't ask the solicitors to advise him. He just turned up to sign some documents. And they turned their mind to Gartside. Remember, the approach in Gartside was, let's not worry about assumption of responsibility, let's just go down the proximity policy approach. And they distinguished it. They said, look, will cases are sui generis. And they distinguished it on a number of grounds. So a solicitor acting in fulfilment of a client testator's purpose and is acting to try and benefit those named in the will, and in those circumstances, the solicitor's duty, Justice Blanchard thought, was based on the fact that no one else can protect the beneficiaries, and they'll be the only ones to suffer loss if the will is negligently drawn. But here, the solicitor's clients were the company and the bank. They had no purpose of benefiting or protecting the directors as guarantors. The bank just wanted enforceable security. The company wanted to give securities so that they could get money from the bank. Okay, so their purposes are actually not aligned with the director's purposes at all. They're actually in conflict. The plaintiff is not totally dependent on the solicitor to look out for him. He's a sophisticated business person. He could and should have arranged for his own advice. He could have asked them for advice, in which case they would have probably said, go and get independent advice. We can't actually advise you. We're in a conflicted situation here. And so that comes down to that idea of reasonable. One of the policy reasons we often see that make courts very reluctant to find a duty of care for pure economic loss is when there are reasonable alternative means of protection. And that is exactly what was available here. This director could have protected himself with reasonable alternative means, which is exactly what Lachlan mentioned earlier. Here's just a quote from Justice. Maybe what we can see here is this kind of movement towards, so we had 1983, we had policy proximity, and this here, 1998, so 15 years later, we're moving back more towards a kind of more structured position around, let's actually look for an assumption of responsibility here. So Justice Tipping said, well, look, in considering whether it is fair, just and reasonable to impose a duty of care in the case of an omission to act, it is highly relevant to the proximity issue that there has been no assumption of responsibility by the defendant to the plaintiff. While I would not go so far as to suggest there can never be such a case, in such a case be sufficient proximity in the absence of an assumption of responsibility, it is not easy to contemplate circumstances where proximity would probably be found without an assumption of responsibility. This is the conventional touchstone upon which the proximity issue is determined. So, where does this leave us? Negligent misstatement in New Zealand, you need to show an assumption of responsibility for the proximity stage of the duty inquiry. That seems to be pretty stable. There are other pockets of liability for pure economic loss found in absence of an assumption of responsibility. There is the reference case. It's a bit of an odd case. And then there are the will cases in the disappointed beneficiaries. Now, what's common about these cases is that the policy concerns that arise that make the courts very reluctant to find a duty of care for economic loss are usually absent. Indeterminacy is absent. There are usually no reasonable alternative means of protection, and there's not a statutory context that goes against the duty. The UK is more conservative in its approach. The court's reasoning shows that they try and get very close to the tram lines of an assumption of responsibility. The New Zealand approach is different, and it was particularly observable in the New Zealand Court of Appeal in the time of Cook and Richardson. They took a looser approach that didn't restrict the inquiry because the loss was economic. They approached it through the wider ANDS test of proximity and policy. But we are seeing movements more towards a stricter approach. So we've got Justice Mellon and Strathboss. Let's look at novel duties of care, incremental by reference with closest analogies, that maintains coherence and avoids inappropriate distinctions. Coherence and clarity and certainty are all desirable things in our law. So there is a hope that things will tighten up. Now, so what do we have? We have about 25 minutes. Why don't you take 5 minutes now, and then we're going to move on to defective buildings. And then by the end of tomorrow, we'll be at the end of pure economic loss, which everyone will be delighted by. So we'll come back 33 past 10. Okay. So I think what we'll do today is we'll just cover... does anyone have any other questions before we move on to defective buildings? I mean, I know it's a complicated area. It's difficult. So if you are do take time to read the cases. They will help. I know they're not the most exciting cases, but, that is just, it's the nature of the area. It's a really important area, particularly when you go into practice in New Zealand. Basically, economic loss is one of the key times you will be engaging with tort law. But aside from that, no other questions? Okay, so we'll move on. So what we're going to do now is talk about defective buildings. And you might groan, you've heard about leaky buildings, so, anyway, what we're going to do is talk about two key cases in the UK, and then we're going to look at the New Zealand approach. But the problem that we are looking at here is, so we have A, who is a builder, constructs a house for B. A fails to follow approved building practices and builds the house with, let's say, inadequate foundations. No one knows about this problem. A year later, B sells the house on to C. Now, the contract of sale excludes any possible liability of the vendor in respect of the state or quality of the building. And shortly afterwards, this house starts to subside. So C then gets an engineer to come and have a look at this house that he's purchased, and the engineer says, look, your foundations are stuffed and they're going to cost $300,000 to fix. The question is, can C recover this loss from A, the negligent builder? Can they recover the loss from D, the local authority who inspected the foundations and approved them? Now, the answer to this question has divided the common law world. But the first thing we really need to do is understand the problem, okay? Because you might think, well, this just looks like property damage. It's just like a building with defective foundations. Like, that's property damage, and so that should just be a straightforward claim. But it's not property damage, okay? So it's not in respect, the owner of the building's claim is not in respect of physical damage to the building. That would be straightforward, okay? If the owner of the building had some contractors around to do some renovations and they left a blowtorch on and that burnt the property down, fine, that's property damage. Just go down, that's straightforward, Donoghue and Stevenson. This is not that. This is for the owner's disappointed expectations as to the true value of the property. The building has been defective from the outset. They have paid too much for it. This is a claim for economic loss. Okay, it is not a claim for property damage. They've paid for a dud. And so what they claim is for the loss in value, so the amount they've overpaid. They paid X amount thinking they were getting this. In fact, they got this, so they pay for the difference. They say, actually, this building is a dud. It's only worth that amount. If I'd known that's all that's all it was worth. Or they pay for the costs of repairing those defects. And so if we just want to compare this to that classic Donoghue and Stevenson, the claim is not for the purchaser of the ginger beer claiming for the physical injury caused after consumption. The claim is for the money wasted in buying it. Okay, because it was a dud. This wasn't worth what she paid for it. Now, the claims that come up here, they can involve all different entities involved in the construction of a building. So the defect might have been caused by the builder who built it, the architect who maybe designed it negligently, the engineer who might have provided negligent advice on what would be adequate foundations. It might be a claim against the manufacturer for the materials used in the building which were not fit for the job they were meant to do. And it might be a claim against the local authority inspector who inspected the building and issued a code of compliance certificate. And what you find is that often the council is the last man standing. So all the other entities involved in the construction have usually disappeared. They build something, you know, and it's been a huge problem in New Zealand. They build some shoddy development, some shoddy building, then they liquidate themselves, so no claims can be brought against them. And the only party left standing is the council, who is then having to deal with all these claims brought against them for shoddy work that they didn't pick up on. So the first owner might have an action in contract against one of those parties. And that's usually where claims for a defect in quality sit. So, you know, you make a bargain with someone and you don't get what you bargained for, you claim for breach of contract. That's usually the province of contract law. But very frequently, and certainly for subsequent owners, that action is not available. They don't have a contractual claim against the original party who built it. And they can't bring a claim against the party they purchased the house off either, because the usual agreement for sale and purchase doesn't give a warranty as to the state of the building. So they're left with claims in tort. Now, the first run of cases that came before the courts in relation to defective buildings concerned defective foundations. And in New Zealand, after the Building Act 1991 and the new regulations came in, there was a shift to claims being for leaky homes. One of the reasons behind this is that prior to the Building Act, regulations were very prescriptive, so they would stipulate that, you know, flashings need to be installed above windows to this depth, etc. Whereas in 1991 they changed it to give more flexibility to building, and they would just say homes must be watertight. And this change from this prescriptiveness to performance-based led to buildings that in fact weren't watertight, leaky homes, etc. So we are going to see that different approaches are taken across the common law world. New Zealand takes the broadest approach to recovery, and the UK the most conservative. UK's approach is very tied to the assumption of responsibility. New Zealand's is policy-based. So what I'm going to do is first talk about the two, probably what all we'll do today is talk about the UK cases, and tomorrow we'll go through 5 New Zealand cases, and then that will bring us to the end of it. Okay. So, question: can the principles of negligence be extended to allow recovery by owners of defective property for the diminished value of the property or the cost of making good the defect? Okay, so because this is a pure economic loss, they paid too much for something, their loss is economic. A principled approach would say only liable if they've assumed, you know, the UK approach, only liable if they've assumed responsibility to the buyer. Reasonable foreseeability is not enough. Now, often the parties are too distant for the assumption of responsibility to arise. So, D&F Estates and the Church Commissioner for England, there was essentially plaster in the plaintiff's flat that had been negligently applied and it needed remediation. And the plaintiffs claimed the cost of that remedial work from the builders who built the flat and put the plaster on in a negligent way. Now the court said, so the court went through and they said, look, if the defect in the building remains hidden until the defect causes injury to somebody or damage to property, then the builder will be liable for that injury or property damage. I mean, that's just a straightforward application of Donoghue and Stevenson. But if the defect is discovered before it causes damage, then the loss sustained by the owner who needs to either repair it or demolish it to avoid a source of danger, that is a purely economic loss. Now, a builder cannot be liable for a purely economic loss under Donoghue and Stevenson. To make him liable would be to impose on that builder, for the benefit of those who had no contractual relationship with that builder, the obligation of one who has warranted the quality of the plaster with regards to materials, workmanship and fitness for purpose. Okay, that would be imposing this warranty on the builder. And they said, look, consumer protection is better left to the legislature. So in the UK, they reiterated here that pure economic loss needs to fall within the principle of assumption of responsibility and reasonable reliance. Now, in coming to this view, they made a comparison to chattels. They thought, well, what would be, okay, this is a house, we're getting tied up because it's a house, it's someone's home, etc. But let's just have a look at what the approach would be if it was a chattel and consider what approach we'd take there. And then, you know, that might keep us focused, and then we can apply that same approach to houses. And they said, well, in no other context has it been suggested that there would be a cause of action in tort law for the defective manufacture of an article which doesn't cause any injury to anyone. And they said, so if I buy a second-hand car and it's got a tyre on it, and as a result of careless manufacture, this tyre is dangerously defective, and it causes damage to the car or injury to me, then I'd have a claim under Donoghue and Stevenson for that property damage or personal injury. But if I discover the tyre is faulty before it causes damage, I don't have a claim in tort against the manufacturer of the tyre. That attaches to those goods a non-contractual warranty of fitness, which follows the goods into whoever's hands they came. Now, there might be a claim through a statutory consumer protection scheme. That's something entirely different, but it's not a claim in tort law. And so the question was, well, given that this is the position for defects in quality in relation to chattels, should there be a different position for defects in quality in relation to houses? And ultimately they said no. So this case involved plaster coming off and the cost of fixing it. Now, they looked at Anne's, where a duty had been imposed in these circumstances, but in Anne's, they had conceived of the claim as being one for property damage, and it wasn't. Okay, they later realised they were wrong. It wasn't a claim for property damage. It was a claim for economic damage. And so they said, look, to the extent that Anne's is authority for the proposition that a builder responsible for constructing a building is liable in tort for damage occurring through the builder's negligence to the very thing he has constructed, to the extent that Anne's is authority for that, that liability is limited to cases where the defect threatens the health or safety of occupants or third parties and maybe property. And any damages would be limited to the cost of averting that danger. But that case could not be adapted to support recovery of damages for pure economic loss going beyond that. Pure economic loss going beyond that can only be recovered if you can bring it into the principle of assumption of responsibility as established in Headley Burn. So there was no recovery here for the cost of remediating the plaster. And the next case, and there was the second case that came up in the Court of Appeal, and I'm sure you'd have discussed this already, Murphy and Brentwood. Have you talked about Murphy and Brentwood yet? Yep, seeing some nods, excellent. So plaintiff bought a house, discovered the foundations were defective, couldn't afford the remedial work, so sold it to a builder who knew about the defects, and the purchase price took into account those defects. The house was sold for £35,000 less than what it would have sold for if it wasn't defective. This was a pure economic loss, okay? And he then sued the council for that $35,000. And he sued them and he said, well, you negligently approved the design of the foundations. And here the UK moved their approach and made it even stricter. And they said, look, where a defect is discovered before any injury to a person or damage to property has occurred, then the expense incurred in putting the house right is purely economic. And they said that local authorities, when they are supervising compliance with building regulations, are not under a common law duty to take reasonable care to avoid putting a purchaser of that house in a position where they would incur economic loss. There was no duty of care owed by the local authority in relation to economic loss suffered by a purchaser of a house who buys a defective home. Now, there were some key things they did in this case. They refused to draw a distinction between a defect of quality and a dangerous defect. This is a distinction that has been drawn in other jurisdictions. They said, look, even if it's a dangerous defect, as soon as you know about it, you can't use it. So it becomes a defect in quality, and you need to either repair it or you need to scrap it. The loss, either way, is purely economic. And they always did this comparison in the UK. They always say, well, what's the position in relation to chattels? That gives us the clarity and we can take it forward. And they said, look, once you know a chattel is dangerous, it's unusable. So if you buy a second-hand car and you find it to be faulty, it doesn't make any difference to the manufacturer's liability and tort if the fault is to the engine or to the brakes, okay? If it's a defect to the engine, it's a clear defect in quality. If it's a defect to the brakes, it's clearly a dangerous defect, okay? And one defect, you can't start the car. The other defect, you can't stop the car. But the liability of the manufacturer of that car doesn't change because of the nature of the defect in tort law. Okay, so before it causes damage to anyone, once you find out about that defect, the manufacturer is no more liable in tort law for the cost of the repairs in one case than the other. There are consumer protection schemes that would apply. They are not tort law, okay? So consumer protection schemes govern a lot of this area. It's not the place for tort law to step in. And so they looked at this and they said, well, these principles apply just the same to a building. As soon as you discover the defect, before it causes damage to damage or injury to anyone, then the loss is purely economic. If the losses flow from a breach of a contractual duty, then you claim them under the contract. You made a bargain, you didn't get what you bargained for. That's what contract law is all about. But in tort law, there is no special relationship or proximity here. And so you couldn't recover unless they could show some kind of assumption of responsibility, which they could not. And they recognise that there may be some cases where even if there isn't a contract, that you could show an assumption of responsibility, but that wasn't the case here. And they specifically noted that the approval, and because we'll come to this because all the local authorities always have to pay for this, but they said, look, local authorities who approve plans and inspect buildings, they do so as part of the performance of their statutory function. The subsequent purchase of that building by a plaintiff is not sufficient to introduce this idea of reliance that would help meet an assumption of responsibility under Headley Burn. And the House of Lords felt that if they allowed claims here for buildings, it would open up a wide field of liability for product liability, essentially introducing this kind of indefinitely transmissible warranty of quality, passing from one person to another. So there was no tort liability here. There is some statutory protection for successive owners of new residential buildings in the UK. But they said, look, if the legislature want the council to be liable, then the legislature should come up with some kind of statutory scheme of liability. It's not a matter for tort law. Consumer protection laws should be left to the legislature. So that's the position in the UK. Essentially, you either need to bring yourself within an assumption of responsibility but otherwise there is no liability for pure economic loss when you buy a building that is defective and worth less than what you paid for it. There is a bit of a legislative safety net. There is the Defective Premises Act in the UK that imposes some kind of liability on builders. That's the position in the UK. Tomorrow we are going to talk about the position in New Zealand, which is entirely different. Anyway, we'll leave it there for today.
Have you got a lot of tests this week and next week?
Yeah.
Have you got
Well, we